Good morning, everyone, and welcome to the Georgia Justice Project's legislative kickoff for 2023. My name is Doug Amar, and I am the executive director here at GJP, we say for short, Georgia Justice Project. And I'm just going to do a quick introduction about sort of our work and some of the issues before I kick it off to the experts here. And I think we're going to hear a lot about our three priority areas from folks on our team. And then we're, of course, going to have some questions and answers. So with that, we'll just jump right in if it's all right. So our organization, as some of you know, hopefully, our work is really founded on sort of two principles, two goals we're trying to achieve. And that's one, to reduce the number of folks under correctional control. And that correctional control is jail, prison, probation, and parole. Trying to reduce the number of folks who are in the system. And as you probably know, Georgia has the largest number of control in the country, 1 in 18. And we've been there for quite a while, unfortunately, in the #1 status. The other goal we have is to reduce the barriers to reentry, so that folks who have been touched by the system, arrested or convicted, we can help remove the barriers so they can more successfully reenter. That's always been our focus. Our work primarily focuses on direct service. We work with, I think last fiscal year, in terms of a client relationship, about 2,200 people across the state, and touched about another 7,500 with regard to information and sessions. So we are very focused, and always have been for our 36-year history, about doing individual work, legal representation, and social services. That work led us about 15 years ago to do policy work. And that's, of course, why we're here today. But our policy work stems directly from the direct service we do every day. We're not sort of just a policy shop. We don't just sort of sit in the room and think of good ideas. It comes directly from the thousands of people we work with every year, and the barriers we see and the issues we deal with as lawyers and as social workers. And then lastly, we do a ton of community outreach and engagement. We say that passing a law is only as good as people know about it and it's being used and enforced. So we spend a lot of time going around the state, talking with folks, doing webinars like this, seminars at various places with many of the folks on this call as partners. And so I think last year we did about 120 some sort of engagements around the state. So that's sort of our approach to change with those two goals. And this slide, just really talks about what is our intervention as it relates to the criminal legal system. I often talk about the criminal legal system in these three chunks. Most people do: front end, middle, and back end. And front end is anywhere from policing through the court system. Middle is the prison system generally, or incarceration. And back end is anywhere after the case is over and someone's not incarcerated, but can still include folks on probation and parole, back to the idea of being under correctional control. And of course, all the reentry issues that come up with someone who has a criminal record. We intervene in sort of every stage of the system. And our oldest sort of work is this holistic criminal defense we've done for 36 years. We're like a private public defender, if you will. But we follow our folks all the way through the system, representing folks on the front end and before someone's in a criminal case, sometimes even before arrest, but certainly usually after arrest. But follow our clients into prison and afterwards and in reentry. Work with our client's family. And that work has been going on, as I said, the longest. We also, about 5 years ago, launched another work just inside a prison, the Metro Reentry Facility. There we're helping remove barriers to reentry for folks at this one facility called the prison system here in Georgia, set up about 5 years ago. But of course, we follow our clients into that area. So we're our criminal defense clients. And lastly, and what a lot of folks know us for is sort of more the criminal record side of all the reentry work we do on the reentry side, mostly around criminal records, as most folks know us for that. But we also do a work around probation and driver's license and other areas. But that's sort of the direct service interventions. And of course, we do policy change. And this is why we're here. And we have, as an organization, have been really blessed to have worked on and changed about 22 different laws since we started our policy work 15 years ago. And most recently, we've had probably some of our most impactful changes in the last 3 years in terms of raw number of people affected, including expanding expungement for certain convictions that reached about 1.5 million Georgians that applies to, as well as the early termination of probation bill that passed last year, SB 105. And most recently, in 2022, I should say, as the driver's license suspension reform bill, we passed SB 10. So we can talk more about that, but we're really here to look forward, not backward, but I want to just sort of ground you all in some of our work. And I will just talk about our policy work in this way. We do our policy work. This is just a way of talking about our policy work. As I mentioned earlier, everything we do is rooted in direct service. in the top left. And then we work across, sort of not just across the aisle, but bringing lots of folks together, certainly bipartisan, but also building bridges to a lot of, unusual and a broad set of stakeholders. And we've been really blessed to work with the chambers of commerce in Georgia, for instance, a number of companies, as well as, of course, nonprofits and directly affected groups. So we've been able to sort of get to some of these results by having this broad approach that's led to these resolutions. And I would also say that our approach is very, very practical. I often say that at the heart of our organization, that we're really just trying to make a change for people, whether it's direct service or whether it's the law. So when we propose a bill and propose a change to a problem that we see, that we really ground it in practicality. And I think that's been one of the reasons we've been able to have such success. Okay, and then I think my last slide before I turn it over to Wade is just, again, I'll recap. This is just a recap of what I mentioned earlier, some of the bills we passed most recently of the 22. But again, in the last 3 years, some of these bills have been affected really millions of people in Georgia, particularly the criminal records, the folks who have a conviction. Again, the first time there's a path to get a conviction off people's records. That bill primarily applies to misdemeanors. There is a felony path. And we're going to talk a little bit about that because one of the bills we're proposing will deal with that and hopefully expand it a bit. And then, of course, our bill in our work around probation. I mentioned earlier that Georgia has the largest number of people under correctional control in the country. And the reason is because of felony probation. It is we are by far the leaders in the country on felony probation. And a lot of folks want to change that. So this bill, SB 105, that passed in 2021, that went into effect, I think that's right, 2021, is starting to have a real impact. And so we heard some numbers recently in working with DCS, Department of Community Supervision, that about 9%, there's been a 9% reduction of folks on felony probation in Georgia due to this new pathway that the Department of Community Supervision and judges and prosecutors are using, and clients, of course, and we represent a few around the state that's having that impact around the state. And lastly is the bill around driver's license suspensions. We got to that work, really working with folks in that prison I mentioned earlier, Metro Reentry Facility, and the suspension of driver's license, which was automatic if you missed traffic court or missed a court hearing. It's called FTA, failure to appear. That is no longer the case under the new bill, and now judges have the opportunity to not only not suspend someone's license, but also to reinstate it automatically and pull it sort of back, if you will, from the process that was in place before, which means that folks who might have missed court or missed court even in the past, the traffic court judge has, or misdemeanor court judges have the ability to undo that and to reinstate licenses without any cost, which is a huge deal because 200,000 people a year in Georgia have their license suspended. That leads to about 50,000 arrests in Georgia. So that's just a quick overview of some of the things we've worked on and some of our recent successes, just to ground you if you don't know who we are and some of our work. And with that, we're going to tee up what we're going to work on this year. And I'm going to pass the ball to my colleague, Wade Askew, who's our policy manager. And he will lead us down the path for the most of the rest of this session. Thank you, Wade.
Thanks, Doug, and thanks again, everyone, for being here, spending your Friday lunch hour with us. So I'm just going to give a little bit of further context as to the criminal system in Georgia, as well as who it is in Georgia who has a criminal record, and then we'll really dive into our 3 priority areas for the 2023 session. So first, just very brief snapshot. For many of you may be familiar with some of these contextual points already, but just to make sure we're kind of on the same page here. The United States is the Western world's leader in incarceration rates. You see here that we are well ahead of other kind of Western nations in the rate at which we incarcerate folks. Georgia, as Doug mentioned, is leading the country in the rate of correctional control. And as Doug explained, that is largely because of how many people are on probation in Georgia. We have by far the longest probation sentences in the country, and that results in this huge probation population that we have. So we're the country with the highest incarceration rate, and then we're in the state with the highest correctional control rate within that country. Of course, this does not affect everybody equally, nationally or in Georgia. So you can see here that while our Black population in Georgia is about 31% of the overall population. Our Black population represents 58% of the population in prison and jail. This is despite no equivalent disparities in actual criminal behavior. And then when you project forward, not just folks who are affected by being in the carceral system right now, but then you project years after, the effect that people of color experience is when they have a criminal record is very different than folks who are white. And so there is certainly a lot of barriers. There are certainly a lot of challenges regardless of somebody's race or ethnicity, but having a criminal record, while it reduces the likelihood of a callback in a job application for everyone, that effect is twice as severe for our Black neighbors than our white neighbors. So this is a very large system that's bringing a lot of people in. It's doing it at disproportionate rates for different segments of the population, and the long-standing effects are very real for everyone, but they are even more profound for, again, people of color. Now, in Georgia, we have all these people brought into the system who get a criminal record. So let's just put some numbers on how many people that's touching and what their criminal records look like at a very 30,000 foot level sense. 4.5 million people have a Georgia criminal record. That's about 40% of the Georgia adult population. Now, of those 4.5 million, we have people on a very wide spectrum, from I was arrested once and the next day the case was dismissed, or they realized they had the wrong person, or I have a long rap sheet with a number of serious convictions. It can be anywhere on that spectrum of 4.5 million people. But of that population, about half in their life have only been arrested once. Also, kind of within that big number, about 1.5 million people have at least one misdemeanor conviction, but no felony conviction. So we quickly shrink down from that 4.5 to get about half people only one arrest. And then when we talk about actual conviction records, about 1.5 million people only have misdemeanor, so minor criminal convictions. And then drilling down further to looking at people with a felony conviction, we have about 645,000 people in this state have an actual felony conviction. Now, less than 10% of those, when we say the word felony, many people think of the most serious offense they can think of. But the type of what is criminalized, what is in a felony sense, that represents a very wide spectrum. So we could be talking about anything from possession of marijuana to murder, things like that. So very, very wide spectrum. I wrote a bad check once, that could be a felony. So less than 10% of felony convictions are actually for serious violence, serious sexual offenses, to again give a little bit of color to this number of the 4.5 million people in Georgia who have a criminal record. What we know that having a criminal record poses, like I've mentioned, for everyone who has a criminal record, we hear every single day the very real, long-lasting effects that it has on folks. Our average client's age is 43 years old. The average age when they got the record was 22. So that means that most people contacting us, who typically contact us because they're having trouble getting a job, actually got their record 20 years prior. So the effects of a record are very long-lasting. What that results in is an unemployment rate that's 5 times higher for people with criminal records than those without. That's despite the fact that we know that almost all recidivism happens within 5 years of an arrest. And so we see this 20+ year effect for most of our clients, but that's despite the fact that even though when their conviction is very old, they're very unlikely to be arrested again. After about 5 years from someone's initial arrest, if they haven't had any more convictions in the meantime, they're typically going to be no more likely to be arrested again than someone in the general population. And so we have this large group of folks who are eager to work, who are currently marginalized, despite the fact that there's really no more likelihood that they will be arrested again than the general population. This is also despite the fact, that these barriers are also despite the fact that people with jobs are actually twice as likely to avoid arrest than those who are unemployed. So as a matter of public safety, it's actually behooves the entire state to have folks with criminal records and folks generally be working as soon as possible. And folks with criminal records are also proven to be quality employees. Studies have shown that they tend to be more motivated, employers experience higher retention rates, and folks with records are actually promoted faster than folks without. And in the background of all of that are some of the strongest liability protections in the country for employers who hire folks with criminal records in the state of Georgia. So all that kind of lays the context for the policies that we are trying to advance in Georgia every year, but specifically here in 2023. I won't get into these three policy areas because you're about to hear a whole lot more about them, but very briefly, they're trying to remove barriers for folks who are seeking an occupational license to free them to pursue a certain profession, expanding access to expungement, and then finally, enabling victim-centered programs to move forward, a new initiative of ours that we're very excited about. So without further ado, I'm going to pass it on to my colleague, Emmy Williams, who's a staff attorney with us to talk about occupational licensing.
Thank you, Wade, and good afternoon, everyone. Thank you so much for joining. My name is Emmy. I'm a staff attorney on the policy team, and for the past 2.5 years, I have had the pleasure of working on issues of access to occupational licensing for people with criminal records. So I've been representing individual clients in the licensing process and doing lots of research about Georgia law and our peer states. And when we talk about occupational licensing, I want to get us all on the same page. So there are about 50 licensing boards and agencies in the state of Georgia that administer state given licenses to enter certain professions. So these are nursing licenses, teaching certificates, insurance and real estate licenses, cosmetology licenses, hundreds of professions that need a professional license given by the state in order to enter those careers. So why does this issue matter? Well, as you probably know, if you want to get a professional license from the state and you apply, a criminal background check is required for every license that you'd want to receive to enter a licensed profession. So there are 3 reasons why this issue of access to professional licenses for people with records matters. The first is that licensed jobs are really common and very in demand in Georgia. And as we all know, we're experiencing a lot of workforce issues, and licensed work is particularly experiencing those shortages right now. So 25% of the high demand growing jobs in Georgia are in licensed fields. And 1 in 7 jobs overall in our state requires a license to do that job. So for people with a criminal record, unfortunately, they are often discouraged or even barred from getting professional licenses because of their criminal record and the additional barriers involved in getting a license. The second reason why this issue really matters is a matter of fairness and access to good jobs. So for people with criminal records, we know their unemployment rate is so much higher than for people without, but licensed jobs are actually really good quality jobs. They offer higher wages, broader employment options. People with professional licenses have lower unemployment and greater job stability. And a professional license can also be the key to entrepreneurship, starting a business or a practice of your own. So for people with records, access to licensed work is a really important element of getting good jobs and getting fair access to good jobs. And finally, having fair access to licensed jobs and professional licenses for people with records is actually shown to reduce recidivism statewide. So we already know that having a job reduces recidivism, and having a good job, like a licensed job, a well-paying job, can actually reduce someone's chances of rearrest by an additional 50%. So it should be no surprise that multiple studies have shown that states that have more barriers to getting a professional license, if you have a criminal record, have higher recidivism rates than states that have fewer barriers to people with records getting professional licenses. So this issue is really important and touches a lot of folks statewide. Next slide. So as we've been working on this issue over the past couple of years, we've had the opportunity to not just represent clients and hear lots of stories from our clients about their access to professional licensing, but we've also had the opportunity to talk with many other stakeholders. Most notably, we have been working in a task force organized by Senator Brian Strickland and also involving several other state senators and legislators. And we've been working with that task force to explore a lot of the issues around access to licensing. We've also had the opportunity to talk with folks in higher education, in workforce development, and in professional associations, as well as state licensing boards and state agencies, other policy organizations, and we've been able to attend some conferences on this issue as well. We've been doing a lot of legwork to make sure we understand the issues and the needed solutions. So I mentioned that for someone with a criminal record, there are some specific barriers that exist in the state of Georgia to getting a professional license. Luckily, there are a lot of reforms as well that other states have implemented to reduce these barriers and make sure that people who are qualified, who have criminal records, get the licenses that they want to work. So I would love to tell you about the first one. Next slide. So the biggest problem that I've seen as I've been doing lots of research and speaking with clients is that if someone has a criminal record and they're interested in entering a licensed field, there's a lack of clarity about whether or not they will be eligible for that license. And this is because currently, if you have a criminal record and you apply for a license, the only time that you get to hear definitively from the licensing board about whether your criminal record is disqualifying is after you've already paid for your education and your training, you've taken your exams and paid for those exams, and you've paid the application fee to apply for the license. Only then does a licensing board consider the applicant's criminal record and whether or not it will prevent them from getting the license. So the solution that other states have created to this problem of a lack of clarity and transparency is to create a binding pre-clearance process for people with criminal records who are interested in getting licenses. This process allows them to present their criminal record to a licensing board that they're interested in getting a license from before they've gone and gotten all their education, training, and other qualifications. So the person can present their criminal record, their rehabilitation, and the licensing board can take a look and say, we have no issues with your record. It's clear that you're qualified. Please go pursue your education, training, and qualifications, and we will license you down the road, as long as nothing changes with your criminal record. Or the licensing board might say, we've looked at your record. We do have concerns. We probably would not license you because we don't think that you are qualified. And either way, whatever answer the candidate receives, they have good, solid information to make their career decisions around. So the effect of this type of reform is to identify lots of new qualified workers with criminal records and empower them to pursue education and training with a clear answer about whether they'll be eligible to get their license. So here are the states that have created this sort of binding pre-clearance process. As you can see, there's a really good handful, and these are actually just the southern and peer states that we think are similar to Georgia. So Mississippi, Louisiana, and North Carolina are the three that I'll highlight here, but there's actually 7 of our peer states that have created this process. The second problem and barrier to folks with criminal records who are interested in getting a professional license is that once someone is applying for their license, they submit, their qualifications and education and their criminal history to the board. A licensing applicant in Georgia needs to disclose every single arrest, charge, or conviction that has ever been on their record. So this is true even if the person has gotten their record expunged or pardoned, or even if the person's record is decades old. And this creates a problem and a barrier because it adds time and effort for boards and applicants. Applicants have to track down lots of information, and boards have to consider all of that information about the person's criminal record that they receive. And in the case of convictions that have been pardoned or expunged, or that are decades old, disclosure of this type of criminal history can lead to unnecessary denials of a license that don't actually benefit public safety. So the solution that other states have created is to say that if someone has received expungement or pardon of a conviction, that those convictions are no longer relevant to the licensing process, and that boards should only consider relevant, recent, and directly related criminal history when evaluating someone's eligibility for a license. And the effect of this type of reform is, first of all, efficiency. For boards and applicants, the process is made more efficient and more streamlined. Boards can look at just the parts of someone's criminal history that really matter, and it still ensures public safety. This is through relying on the expungement process and the pardon process, where someone is already taking a good look at someone's rehabilitation and their progress since their record. And it also applies lots of research that we know about desistance and the period of time in which a conviction is relevant to someone's employment or their license. So here are the states that have taken steps to streamline the consideration of criminal records in the licensing process to just most relevant, recent, and directly related. So 4 of these states have actually created time limits, 4 or 5 year time limits where a conviction is no longer relevant once it is past that 4 or 5 year time limit, unless it is a serious sexual or violent offense or an offense involving domestic violence. And 4 of these states have also said if someone has gone through the work of getting expungement or a pardon, or if they simply have an arrest record with no convictions, that those types of records are also not relevant to the licensing process. The third and final barrier for folks in Georgia with criminal records who are interested in getting professional licenses is that once someone applies for their license, the process of showing their eligibility to the licensing board can be a difficult and an unclear one. And if someone is ultimately denied a license because of their criminal record, it can be difficult to get a second opinion through an appeal to make sure that the licensing board's decision is correct. So the solutions that other states have implemented are first to clarify whose responsibility it is to decide whether someone is eligible for a license. So requiring licensing boards to show that an applicant is ineligible by a certain standard of proof, usually by clear and convincing evidence. That takes the burden off of the applicant to show that they are eligible, puts it on the board to show ineligibility. Other states have also said that it's important for licensing applicants to be able to bring witnesses to speak to the licensing board about their eligibility and to present evidence of their eligibility to the licensing board. And if someone is denied a license, other states have created a requirement that licensing boards need to explain their decision in writing and tell the licensing applicant what part of their record was disqualifying and why. And then finally, other states have also taken steps to make sure there's an accessible appeal process. Right now in Georgia, if you're denied an occupational license because of your criminal record, you pretty much have to hire an attorney in order to get a second opinion on appeal. But other states have created an easier pathway to appeal that allows people to do that without hiring a lawyer. And the effects of all of these reforms are again, to give more guidance to licensing boards, making sure that they have a clear standard that they're applying, and also to make sure they have as much evidence as they need to make a good licensing decision through listening to witnesses and considering evidence. And for licensing applicants, they get to understand how the law applies to their record, and if they are denied a license, what they need to change or work on before they reapply. And then finally, as a matter of fairness, for someone who's invested a lot of time and money and effort into getting qualified for a license, allowing them to have an easier appeal process to get a second opinion on their eligibility for the license is really important. So these are the states, our peer states, who have taken steps to make sure that there is due process and clear process for people who are applying for licenses with a criminal record. So again, I'll highlight Louisiana, Mississippi, North Carolina, Missouri, and Kentucky. All of these states have taken steps to make sure the process is clear and fair. And then one final note on licenses. So to this point, I've been talking about professional licenses that are held by an individual. But there's a different type of licensed work in Georgia, and that is working for a licensed facility. And one issue that we have seen with our clients is if someone wants to work at a licensed facility, specifically a long-term care facility, such as elder care or care for people with illnesses, there are some barriers to working in that setting that are pretty severe. So if you have a conviction on a list of over 200 and you are hoping to work in a long-term care facility, you are disqualified from working in that setting for 10 years after your sentence is completed. And the reason that this is really severe, the reason why this is an issue is because we know that Georgia has the longest probation sentences in the country by 60%. And actually 40% of Georgia probation sentences are over 10 years. So for someone with a lengthy sentence, as is typical in Georgia, adding an additional 10 years after the sentence is completed can lead to people being disqualified from working in a licensed facility for decades. And there's just no study that supports that someone's criminal history is relevant for a period of decades. So the reform that we are proposing this session is to retain that 10-year disqualification period, but begin it at conviction, not at sentence completion. And also, if someone has gone through the huge effort and achievement of getting a pardon from the State Board of Pardons and Paroles, that the 10-year disqualification does not apply to a conviction that has been pardoned. So that's a lot of information. Thank you so much for listening and for tuning in. I want to also encourage you, if you have a story, if you're someone with a record who has been denied a license or is trying to get one, or if any of this has resonated with you today, please feel free to share your story at the bit.ly link. I'm sure it'll be dropped in the chat as well. And I'll turn it back over to Wade for more about our next policy priority.
Thank you, Emmy. And everyone should know, Emmy has really spearheaded our efforts in the licensing space and has really put us in what we hope is a strong position to move forward into this session to hopefully get these things done. So I'm going to shift gears and speak about record restriction or expungement. Obviously, this is how many people know Georgia Justice Project, and it will always be a priority of ours to both improve access to and improve the impact of records that are restricted in the state. So first, I just want to talk a little bit about the benefits of expungement. There are 3 benefits that we list here that touch not only the individual who receives expungement for a past conviction, but also their entire community and the state at large from an economic standpoint. So first off, expungement creates opportunity. Wages increase within 1 year of expungement at a very high rate. This 22% increase of wages on average that you see here. This is really no surprise when we know how the severe effect that having a visible criminal record has on folks when they go apply for employment. As a result, since we know that having a job, and especially having a good steady job, significantly reduces recidivism, it follows that getting an expungement itself reduces recidivism. So for example, one study has found that less than 1% of folks were reconvicted of a felony within 5 years of clearing their record. Finally, expungement strengthens the economy. The economic benefits of expungement significantly outweigh the costs of implementing expungement. And again, there should be no surprise, because one, we are reducing recidivism, and two, we are getting more people into the workforce, making with steady employment, with higher wages, which obviously feeds right back into the economy at large. This is just a snapshot of where we are in Georgia when it comes to record clearing, whether it's what most people call expungement or other forms of record clearing. I am not going to dive into the details of everything that's out there. What I will highlight, and what is relevant to what we're going to be working on in 2023, is that is the restriction and sealing portion of this slide under convictions. So prior to 2 years ago, if you had a conviction in the state of Georgia, outside of a narrow exception, there was no way for you to pursue expungement, or what we in Georgia call restriction and sealing of your offense. We now have our first law that covers people who have certain convictions that are eligible for restriction and sealing. General overview of that law is that most misdemeanors are eligible for expungement, most but not all. However, even if you have more than 2 misdemeanor convictions, even if your third or fourth or what have you would be eligible, that does not matter. You are capped at 2 misdemeanor convictions in your life. I'm going to loop back to this in just a second, but that's a significant limitation in our current law. If you have a felony conviction, the only path for you to have that case expunged or restricted and sealed is to first get a pardon from the State Board of Pardons and Paroles. Getting a pardon is about a year-long process. Only about 500 people successfully navigate that process each year, so it's a very narrow path to then become eligible for expungement. And under current law, if you go through that year-long intensive process that's going to involve a state investigator, it can include an interview in front of the actual State Board of Pardons and Paroles. After all of that, you then have to start over by filing a new petition in court, arguing your case again, and hoping that it's then restricted and sealed. Again, we're going to loop back on that. For both felonies and misdemeanors, there are excluded offenses. There are certain types of offenses that currently are just simply not eligible for expungement. And I'll loop back on one of those types of cases in just a second. Now, our legislation for 2023 is going to seek to, again, help more people and also streamline the process, make the current law work better for more people. First, we need to clean up the current law. You see here a list of elements. I'm just going to highlight a couple, but there are a number of technical fixes. Now that we have a law that's been in practice for a couple of years, we've seen in practice where some of the hangups are. That's going to be the case with any law, and it's no different for record restrictions. So first, one thing that we've been running into is that there is an inconsistency when it comes to how misdemeanor theft cases are treated. So there are a number of forms of misdemeanor theft. So theft by shoplifting, theft by taking, there's 16 different forms. Only 2 of those are currently eligible for expungement. The others are not. There's not really a rhyme or reason for that. It's very similar offenses that could frankly be charged differently jurisdiction to jurisdiction. Same behavior that's charged one way in one county, another way in another county, and your eligibility for expungement just depends on how you are charged. So what we would like to do is bring consistency to that. All misdemeanor theft, we believe, should be eligible for expungement. A second thing we've run into is, again, folks who have gone through that process, that very intensive process of getting their record pardoned, to not make them have to start all the way over, to start from scratch when they then go to restrict and seal. If their pardoned offense is eligible for restriction and sealing, which would be any felony that is not a serious violent or serious sexual offense, if it's any other type of felony, then that means if it's pardoned, it is eligible, then we believe that the process should be streamlined. So I got my pardon, I file my paper to court, a judge confirms, okay, this person is eligible, I'm going to stamp it. We're done. We don't need to reprove your case here because you just went through this very, very intensive process. There are other technical fixes that you see here that we've run into. Some of them are unintentional from the original law from a couple of years ago. So we need basic fixes to do things like ensure that trafficking survivors don't face unnecessary delays to seal their records, to make sure that folks with very, very minor offenses that actually are eligible for expungement are physically able to expunge their offenses. So there's some technical fixes. If you have questions, we're happy to speak about those individually. But that's how we can clean up our current law. And then the second major thing that we need to do is to remove the barrier to clearing eligible misdemeanor convictions. So we talked about this limitation that folks can only expunge up to 2 misdemeanors in their life. What I'll say is, in my experience as a practitioner for a number of years, very often the folks that I would work with who had more than 2 misdemeanor convictions in their life were coming from some of the most difficult circumstances of any of my clients. People who you would look at their record and there was a number of minor offenses that happened in a defined period of time, and suddenly it stopped. And you'd ask a question and you'd say, what was going on at this time of your life? Very often it was, I was experiencing homelessness at that time. I got a home, I got a stable employment, and then boom, record's over. I was a survivor in an abusive relationship. I was able to get away from that situation. Boom. The offenses that were on my record were related to that, and they ended. I got out of that situation. I was dealing with substance abuse at the time. I was dealing with addiction at the time. I was able to get clean. I was able to move on. Boom, my record ended. Anecdotally, that is very disproportionately who we're talking about when we're talking about people that have more than 2 misdemeanor convictions. And so there would be a very significant impact to be able to extend relief to folks who have been in those positions. Also, we've been talking about actual data around recidivism. People who have gone 4 years without being convicted, which is already a requirement in current law. Whether or not they have 2 misdemeanors or 3 misdemeanors on their record, their chances of reoffending are extremely low. And so there's not really a public safety rationale for the current limitation. And then finally, I'll just highlight many states in this country are moving towards an automated process of how they handle record restriction. If we want to get there as a state in Georgia, which unfortunately that's not part of our agenda this year, but if as a state we want to get there eventually, this lifetime limit would not work in an automated system where a computer would have to decide this person has 3 misdemeanor convictions, which 2 am I going to pick? It just simply wouldn't work. So even in our long-term thinking, that is a barrier to where the state may want to move in the future. If you are in a position or have been in a position where you have multiple misdemeanor convictions on your record, where you know that the current limitation of 2 is going to hold you back, you're not going to be able to fully clear your record as a result. We'd love to hear from you. We'd love to hear your story. So again, we have a bit.ly link here, which will also make sure to get out to folks where you can share your story, because adding some color, making legislators understand the real people behind, the real stories behind who are affected by these laws, that does matter. It does kind of move minds. So please do share if you're comfortable and you would like to. With that, we're going to shift to our third and final priority for this year, which is enabling victim-centered programs. So I'm going to kick it over to my colleague, Rami El-Harib, our Restorative Justice Program Manager, to describe a little bit about what we're doing on the ground, and then we'll talk about what we want to do legislatively.
Thanks, Wade. Hi, everyone. My name is Rami El-Harib. I'm the Restorative Justice Program Manager And so at GJP, we have started this really great program called Restorative Justice Georgia. It is a victim-centered program where we accept cases of felony for adults or for youth who are being tried as adults. So why is this important? When we talk about being victim-centered, we know that in our traditional criminal justice system, we focus a lot on punishing the person who has committed the harm, and we don't listen to the person who has actually done the harm. Sorry, I think that I have an echo, so maybe I can fix that. Is that working better? So, victim-centeredness, we want to focus on the people who have been the most affected by harm, the survivors. We want to listen to them and what they need. We know that when survivors go through the system, it can be very exhausting for them. It can be very intimidating and can actually re-victimize them. So we want to shift from what has a person done and how will we punish them to obligation to the survivor, to what does the survivor need for rehabilitation. And so how this program works is going to, most of these cases are going to come from the district attorney's office. They're going to be pre-indictments. So we're going to get these cases from the district attorney, obviously with the survivor or victim's consent. I will speak to both parties, the harmed party and the responsible party, make sure that they're both ready for the process. Once they're both ready, I bring them together into a conference or a dialogue. And from there, we explore the harms, what people need, and come to an agreement of how to move forward from this. And then after that, we work with the responsible party to support them in completing the agreements that the survivor or victim has asked for. And after that, hopefully, their case will be dismissed or reduced.
Thanks, Rami. So that's a little bit of background of kind of what we're doing, what we're talking about when we talk about restorative justice as it works actually on the ground. So I'll talk a little bit about some of the broader benefits of victim-centered programs and restorative justice specifically, as well as what we're actually looking to do legislatively. So first, some of the benefits for crime survivors. Crime survivors support very high rates of satisfaction, much, much higher than rates of satisfaction for victims who have experienced the traditional criminal legal system. Victim-centered programs and restorative justice, they make a space for healing. They're designed, as Rami explained, to be trauma-informed, to center a survivor's needs. And we also find, and studies have also found, that where restitution is ordered in a case, for folks who have been through this process, restitution recovery rates are actually higher for folks who have been through a restorative justice or other victim-centered program. Prosecutors, we have heard from a number of prosecutors that this is a tool that they want. So there need to be multiple tools out there for addressing harm that happen in a community. There isn't necessarily a one-size-fits-all approach. And so this is simply an additional tool that, again, we know from talking to them directly that prosecutors actually want and can use, and that also survivors report wanting this as an option, as a tool that they can opt into. For the community at large, studies have shown that restorative justice reduces recidivism and actually helps communities be restored. Rami kind of described that as part of a restorative justice circle or session or program. Not just the person who suffered harm and the person who caused harm are present, but also potentially members of the community can be there. So the community has a voice in this. And we know that when harm occurs, it doesn't just affect one person necessarily, it impacts an entire community. And so there's a space for actual communal restoration here. And then finally, from the standpoint of folks who are accused of crimes, for the defendants, there's an opportunity that we know many of our clients want, which is the chance to make things right, the chance to be part of that healing, to try to help somebody who has experienced harm or do their part to be accountable. That is actually something that many defendants want to do that the current system prevents them from doing for a number of reasons. And so this creates that space. And also, someone who successfully completes this process, it can prevent these unnecessary lifelong records that we know have such a drastic impact and the many collateral consequences associated with them. And so what we need on the legislative side to enable these programs to get up and running throughout the state is a privilege in the evidence code. So what a privilege is basically a rule of evidence that says, hey, if you make a statement, a communication in this context, we're not then going to call that statement in as evidence in a court case. So you may be familiar with these privileges in other contexts. So something like in a mediation session, that discussions we have in mediation are privileged, meaning that, again, if our mediation breaks down, we don't come to a deal, you're not then going to say, well, Wade said in mediation that, he was sorry that such and such happened, and therefore, I should get all the money here. Same thing we have in current law, that if a healthcare provider makes an apology to someone, that's privilege. That apology is privilege, meaning it can't then be used against them as somehow that they've admitted to doing wrong and they're liable for medical malpractice. So this is not a foreign idea. We have it in current law. Other states have done this to say that that communications in certain settings, and specifically in a restorative justice or a victim-centered program setting, should be privileged. That's so important here because acknowledgement of wrongdoing and open dialogue is core to restorative justice. It simply cannot work if a defendant cannot feel comfortable that they are in a safe space to say, I'm sorry that this happened to you, acknowledge any wrongdoing and try to make things right. The traditional criminal legal system does not allow for that, because if I say those things in the current system, all those statements will be held against me. And no attorney in this state is going to let their client say these things. Also, the current system will probably actually prevent me from ever being able to have any communication with the survivor of an offense. So we have to have this privilege to protect those communications, or else the programs can't even get off the ground. So that is the three things that we are hoping to accomplish in this legislative session. We highlighted in a couple of spaces where we'd love for you to share your story, whether it's around expungement, and especially folks who have multiple misdemeanor convictions, whether you've are interested in applying for a license or you've been through the occupational licensing process. We'd love for you to share your story. You can stay engaged with us, sign up for action alerts, sign up to stay attuned to what we are working on. And then you can always support us. We love folks who volunteer with us. And you can reach out. My email, my phone number are here. So with that, we've still got a few minutes. And so we're happy to take any questions. I know that there have been a few in the chat. And so we will take a look at those to see if there's any to answer live here. All right. I see that we're typing the answer to one question right now. But otherwise, so I see one question: what pushback have you received on licensing? Fortunately, at this point, as we mentioned, we have engaged as many stakeholders as possible, and we have found really wide support. The business community, chambers of commerce, workforce organizations. We've really met a lot of people who think that this is a way to try to address some of the workforce needs in Georgia, and it's also simply a matter of fairness. We'll see. I'm not so naive to think that we'll never encounter any resistance, but we're at this point hopeful. And then one other thing that I do just want to make clear, that shifting gears a little bit, talking about restorative justice, is that we as an organization, we are already doing the work of restorative justice, and we're doing it whether this legislative change happens or not, because in the jurisdictions where we're practicing, we basically have agreements already to do the things that we're talking about. So we have agreements that communications are going to be privileged in the restorative justice setting. But if we want this to grow outside of the jurisdictions where just Georgia Justice Project has an agreement, and also if we want to continue to make defense attorneys and folks who are defendants comfortable by seeing something in statute, in law, that says these are protected, then we think that this legislative change is needed to help these programs grow and to help them flourish. So rest assured, Georgia Justice Project will be doing this work on the ground now and in the future, with or without this passing, but we do think it's very important for it to continue to grow and to thrive. All right, not seeing any other questions. Just want to thank everyone again so much for being here, and thank you for staying engaged. If you have any questions or you want to reach out, please do. My contact information is here, and we would love to hear from you. So have a great weekend, everybody. And we, again, are grateful for your partnership and your presence. Thanks.